We have two eminent guests in the studio. Before we introduce them and welcome them, let them hear the day's proverb from South Sudan.
Yes, it's a simple and straightforward proverb. Don't cough in a hiding place.
It's a good one.
Don't cough in a hiding place.
Unless.
There will be consequences.
You'll definitely find out what the consequences would be. Hey. Our guest in the studio this morning, Abdulkadir Mohammed, Senior Counsel, who in this particular petition was among the lawyers representing the Independent Electoral and Boundaries Commission. And KAMOTHO WAIGANJO, who is an advocate and a two-term member of the First Spouses. It's called what?
It is now first spouses. It should be called first ladies.
I was very careful to actually use the word spouses. The chairman of the First Ladies Club. Gentlemen, welcome to Kenya's biggest conversation. It's good to have you on the show. When you hear that proverb, let me start with you, Abdulkadir. Don't cough in a hiding place. What do you think the South Sudanese are saying?
We have a similar, not necessarily similar, but among the Somalis they say, if you steal a drum, where are you going to beat it? So the Africans have very good sayings. Yes.
Yeah, be careful. I mean, choose what you steal.
There you go.
Make sure that you're stealing something that you can use.
Yes,
KAMOTHO, what do you think?
Well, I suppose one is to the richness of our language, but also that be careful when you steal because in terms of usability of what it is that you're stealing, now relating more to the Somali proverb, the usability is reduced by the nature of the item that you have stolen. And I think in relation to, if you want to reflect in terms of this election, I think, there were numerous allegations made in the election petition, but clearly not supported by evidence. And in a sense, one can say, if you're going to allege, then you better be willing and able to prove.
Yeah. Be ready to play. To play the drum at a public place. We were waiting for the judges to come out. Though it wasn't clear was it going to be a unanimous decision, was it going to be a decision by majority, or they going to send us back into an election by nullifying this, or they going to uphold it. And then they came out and they said this is unanimous and this is the verdict of the court. And when the Chief Justice was reading through the issues one after the other, you then got a sense of where this was heading just from the first one. The first issue was technology. Did IEBC actually deploy technology that was had integrity, verifiability, security, transparency, and the issue that were then brought before the court? And they were saying, well, we looked at this, we looked at the evidence of the petitioners, we looked at what the respondents were saying, we disagree. All along, among the things that I'll speak for myself, the things that stood out for me were the judges questioning what was being presented before them as evidence. And sort of like the judges expressing frustration with the lawyers who were representing their clients with how the lawyers were presenting the evidence before the judges. Did you get that sense, Abdulkadir?
Yes, thank you. Cases are stories. When you present a case, you're presenting a story of how things happen. And you have to have a credible story backed by evidence. So it was not credible what the petitioners presented. It was not in fact true, and they were unable to prove. So I think that's the frustrations the judges were stating. Look, you are telling us all these very weird things. So that's the second is you have to understand your case. What is the case about? It's about elections. Technology, all these other things are processes that help with the election. So ultimately, the core of the case is the substance is an election. and elections are well known in this country and many other places, and they happen right at the polling center. And the polling stations are not, it's not a benign environment. They're very contested, active environment. The public is there, the voters are there, you can see what happens. It's not something you can say strange stories about, however interesting they sound. So I think the key is the lawyers say, he who alleges proofs. When you allege X, you should, as Counsel Wakili said, KAMOTHO said, you must be able to prove. It's not just about laying outlandish claims. You have to have the substance to prove your case. So I think that's the frustration there. The other is, this is a very serious matter. When you are the Supreme Court, usually, it's a very serious business. When you're dealing with the elections of the president in this country, it's a matter of life and death. It's really the livelihoods of the 50 million people. If the court had said, go back for a rerun, for the next 2 months, the economy would really be in trouble. We would all be worried about what's going to happen, and some people would lose life. We almost always, in any election, lose life. So really, you have to take it that seriously. It's really a very weighty matter. So when you come and say all these issues happened, you should really have some basis for saying those. Yes. Yeah.
Eric, I don't know whether Azimio had a good case. What I know is they presented a poor case. They presented a poor case. It was very clear that, one, they had not prepared for the possibility of a petition. And you can tell that by the amount of evidence that you've collected. Because traditionally, and the reason why, by the way, people talk about have agents in polling stations, because people assume have agents so that the election is not stolen. That's not the issue. The issue, have agents so that if there's a problem, you have evidence, and you're not collecting it from the commission. Because you see, you're suing the commission, but it's very clear the bulk of the evidence that Azimio were presenting were actually coming from IEBC. You needed to have your own evidence. If you want to do a recount, for example, in specific polling stations, you better know that those polling stations have a problem, because your agents have told you there's a problem there. If you are throwing a dice and hoping something comes out, it can be very, very dangerous. So I think there's a sense in which one felt that there was not sufficient preparation for the petition. And don't forget that if you have not prepared before the date of declaration, there is no time. There's actually no time. Those few days there to put papers together, to get your lawyers in place, to agree what is the theme, it can be very difficult. And that is why you find that even in terms of prayers, the prayers were convoluted. On the one hand, you're asking for a declaration of your candidate as the president, as a winning candidate. But at the same time, you're saying this election was very badly managed. It was inconceivable that it could produce anything. On the same one, you're saying nobody reached 50% plus one, and then you're asking for a declaration in your favor. So you sense that in terms of the nature of prayers, there had not been sufficient time to process it. Now, having said that, you then go and present a case to the court. And this is a serious court, You present a court on issues that are not backed by evidence. Because at the end of the day, and to support my brother, what is an election about? What is a dispute about? You are trying to establish what was the result. And is that result verifiable, which is where the process comes in. Because this is not just about numbers, and I think it's important for people to, it's not just about numbers, but are those numbers verifiable? Do those numbers emanate from a fair process? If you're not able to show that, the numbers are there and you're not able to impeach them on the basis either that they are not verifiable or that they arise out of an illegal process, your case is very, very difficult. And it doesn't matter what else you present. It may be interesting, it may speak to other constituencies, it may have collateral objectives, but in terms of convincing the court that you have a good case, you must be able to impeach that result. And that, unfortunately, did not occur. Yeah.
This is where I get confused. I always get confused. Because I listen to when you learned...
Friends.
I was going to say fellow citizens.
Yes, that's all right.
Yes. When one side presents a case, you listen, you say, okay, these guys have nailed it. The other guys come and you say, hey, these guys have also nailed it. So, where
Who has a bigger nail?
are we? I mean, what I am confused about is there a definitive threshold for what is considered to be credible evidence? So that when I hear it, I know, okay, that one is credible, okay? As opposed to that is a story I'm being told, but is there a threshold that one can look at?
Can I try? I think it, and it's possible to take each of those issues. For example, you come to the court and say part of your evidence is that forms somebody entered into the server and into the portal and amended and changed the forms. That is an allegation. So you must be able to come with evidence, one, showing this is at the original form, because the original form exists. This is the form in the portal. Look at the numbers. These are the numbers in the original. Look at the numbers in that portal. In fact, if that evidence was there, when Advocate Julia Soweto, who did a great job of live transmission, she would have been saying, let's take the next 5 polling stations. These are the original forms. Let's take you to the portal. You see the changes that were made, the changes in the numbers. Then you can convince the court. But if you tell the court there were changes, and then you produce logs and produce complicated, but the essence of that issue is that there was an amendment to the document. Let's take an issue like there's somebody who was entering the log 1,000 times. Then you need to be able to show, one, that thing happened first, factually, and then number 2, that the effect of that act, because it's not enough to say 10,000 people hacked into the system. You know, you need to show that the effect of that is that then it compromised the result. If you don't make that link, then that is a problem with evidence, that the evidence can look very overwhelming. But in terms of the issues that the court is talking about, for example, the first question was about whether the system was credible, was strong enough. Again, whose evidence will the court believe? In 2017, the court was at sea. It depended on the parties to fight over that issue. Remember, that's why the court finally was not clear about the status. And they said the server was not opened, or at least that was the ultimate conclusion. But this time, the court had its own people. And if you look, because the report is available, you'll notice the number of ICT professionals. I think there were about 10 or 11 who were there, senior ICT professionals. So the court was able to make its own independent determination. Because otherwise, on something like ICT, you see on the forms, everybody can see. But on something like ICT, parties can tell you anything. ICT professionals can take you left, others take you right. So the court said, no. On this one, our registrar will look at it. And depending on what the result that the registrar comes with, that is what matters. So that's what I'm saying. So those are the various areas in which you can check the credibility of evidence. One, by the evidence itself, and then by objective third parties.
And then the system had a lot of checks inbuilt. So, for example, at the polling station, you vote, the process is very regulated. Even the color of the box is regulated. How that process happens is very regulated, and everybody understands. So you come into the polling station, somebody picks your ID card. So they look at it, they confirm, you put your thumb, your details come through, you're given a paper. Assume your name didn't pop up. Then there's a second level. You pick your ID card and look into the machine so that it can look at your features plus your ID to see whether it can get out of its database your details. In the event that doesn't happen, the presiding officer then has to call everybody, your agents, the other parties' agents, everybody, and say, look, this good person here, his details have not popped up. We need to go to the register. Then they go to the manual register,
the physical
with
register,
everybody around, and anybody can object. And then they take your, when you open the station in the first place, they have to show everybody that the boxes are empty, that the ballot papers have come in a sealed, that your agents can put their seal on top of the IEBC seal so that it's not broken. So this system, the way it's designed, there are a lot of checks in the system. So all you needed to show using those checks was that what was expected didn't happen. Now, evidence is a whole school in terms of legal study. There is direct evidence where somebody can tell you, oh, you're dealing with somebody who was shot. I was there standing. Somebody was shot. This is the gun. That's why it's called a smoking gun. That is the best evidence. I was there. When the guy shot him, I was there. This is the gun. I saw it smoking. That is called the smoking gun. It doesn't have to be direct. It could be indirect. It is that, oh, I saw he had a problem with this fellow for the last 2 years. They were fighting over a piece of land. Yes. On the day this person died, I saw him carrying a gun that day. I don't know whether the gun was found, but I saw him carrying a gun. Oh, they were hard quarreling that morning. And it builds up. It's called circumstantial evidence. It builds up to the point where you can say. And finally, the judges are professionals. They have had and seen this many times. So from their experience, from the information you have delivered, from knowing the way the system works, one can say, yes, this has been proven. No, this has not been proven. Now, it speaks to good lawyerly work when I tell you one story and you shake your hand and say, that sounds very reasonable. And KAMOTHO comes behind me and completely, that is why it's supposed to be an adversarial system. You're not supposed to listen to one and go, aha. No, you're supposed to wait for the rebuttal to come and then make your mind after the two have been presented. Yes.
Okay, if we look at 2017, as a result of the judgments that were made in 2017 after the petitions, then there was a way forward for future elections in the country. And then we saw that the manner in which these elections were carried out in 2022, by and large, were from the declarations made from that, right? And then there were some lessons to be learned for each practitioner across board to do something. Now, come 2022, because now obviously we're looking in a forward trajectory. It's done. And if anything, we heard from the courts yesterday, it was not a matter of process having gone wrong. It was not a matter of technology having failed. It was an issue of what you brought to us we couldn't deal with because we didn't see it. What would then be the thing then moving forward in the practice of elections that then can be taken away from this by all parties?
Oh, thank you. And I think that really is the story of our election process has been learning and reforming. Remember in 2007 we held the elections. And in 2008 or 9 we disbanded the entire ECK. It was called ECK those days. Completely disbanded that institution. Sent everybody packing. In fact, by law, made it illegal for those people, the good people who are in the ECK then, to hold any job in the election management process in this country ever again. Very punitive. Then we had a whole new infrastructure for elections. We had 2 different institutions, one for boundaries, one for elections. Did the chapter, they were called Article 4 reforms, I think.
Chapter 4
Chapter 4 reforms. And
Agenda 4.
Yes, Agenda 4.
Yes.
Agenda 4 reforms under the Accord. Went over a decade of reforming that process. And then we came to 2017. And the court said, now, presidential elections are rarely nullified. In fact, there are very few countries where a presidential election is nullified.
Only 5 in the world.
Thank you very much. There you go. So it was really a very radical decision the court took and said, look, go back to the drawing board. So over the last 5 years, the election management body has been on a path where they said what went wrong and how do we correct it. That's why they were far much better prepared this time, not just in terms of doing the elections, but also preparing for the case that was coming. So we have learned substantially, and I think one of the things we have learned from where I sit is that it's not necessarily the elections or the institutions that are the problem. If it is the institutions, we disbanded the institution in 2017. 2007. After 2007 elections. If it is how the elections are held, we sent everybody back through the court process. So the courts have done their work, Parliament has done its work. unfortunately, there is something that neither the courts nor Parliament can do that might be the matter. And that is our politics. I don't think you can legislate or litigate trust or good behavior. I mean, you need a minimum of trust for your life to run. So, for example, we came driving this morning. We assume the other drivers are sane and we drive reasonably well.
Yeah.
Because these are huge objects moving at 100 kilometers an hour. If somebody and you're passing less than 50 centimeters apart.
Yes.
And if just somebody swerved like this, you are dead.
Yep.
But you assume you will be driving at 100 kilometers and the other fellow is reasonable. You go to hospital, you are injured or your child is injured, they'll be rushed into an emergency room and you don't know whether the doctor is qualified or the nurse, that chemical she's putting into that child, you don't know what it's made of. But you have a certain level of trust that whoever is doing that is not going to be a mad person. So that minimum level of trust has to happen in our politics. I mean, we have to have a minimum level. You cannot reform our election management process to the point where you can go ahead without zero trust.
You know, you hit the proverbial nail on the head. But then I have to ask something less proverbial.
Yes.
I mean,
Yes, sir.
how, in your opinion,
Yes.
WAIGANJO, how did we get to the point where our entire reference infrastructure emanates from mistrust? How did we? It wasn't always. How did we get here?
I think in our electoral process, don't forget that our mistrust actually arises in respect of the presidential election. That is what is interesting, because we are very okay with all other elections, which happen on the same day, with the same officers, with the same infrastructure, with the same register, with the same KIMS.
And the same voters.
And the same voters. But when we get to the presidential election, the KIMS is horrible. Same thing. So the question is really about the presidential. It's not that Kenyans, we don't generally mistrust institutions. But it's because we come from a culture where the presidency means everything. So to gain it or to lose it has such high stakes. There are very many people invested in that loss and in that winning, that it is important to impeach it. One, for purposes of issue, if possible, so that we can, get another bite at the cherry. But also so that if it's possible, we can also be part of the family of those who won. That's been part of the problem. And for as long as we continue to make the presidency the do-all, the make-all, we're going to have that problem. When we were talking about the imperial presidency in the good old days when we were changing the constitution, that was part of the reason. We said it shouldn't matter that much that we're willing to go to war, because people know if you lose the presidency, you have lost everything. So what are some of the things we are supposed to do? One, devolve the presidency, at its level. Make sure that the other institutions that exist to have competing power with the presidency. Make sure that the president does not have decisions that are not checked by other institutions. But number two, also devolve downwards, so that you have counter governments, you have resources at that level, so that, unlike what Mo used to say, Siyasabaya Maishabaya, even if you vote the wrong person, and even if you don't get the presidency, it does not mean that you're not entitled to the national resources. We even constitutionally required that resources, not just the ones for devolution, even the ones at the national level, must be spread out equitably. When the government is doing roads, it won't just do roads where it was voted for. Unfortunately, we have backtracked on a lot of those things. That has been our problem. If you look at the trajectory between 2013 towards from when we've had our first county government elections, if you look at even allocation of money to the county governments, it's actually come down. It started off very well going up, it stagnated, it's come down. And not only has it come down in terms of actual money, it has also come down in terms of when it's released. It's not released on time. In the intervening period, the presidency has also become very powerful. The president is the one that decides we're going to have an expressway in Nairobi, and he can spend 100 billion shillings, 500 billion shillings. The presidency can decide whether there will be development in Nyanza or whether there wouldn't be. So again, we've gotten to the point where we've realized the presidency matters a lot. And so part of that mistrust in the system is also engineered to reach a particular a particular. Now, unfortunately for us, and this now I say both to the professionals and even to the media and how we tell the story, we also have bought in, we've also bought in, and we've also now become cheerleaders that push that story of mistrust. So that I kept saying to myself, why isn't it like there was evidence that was given, Abdikadir, if you remember, about I think it was the chair's PA, and I saw it. It was the headline of one of the newspapers that how the election was stolen. This person entered the server 1,000. Nobody sat back and said, "Wait a minute, this is a human being with a family. But we are telling this story without asking the question: what does this do?
What was he doing?
Yeah, what is it happening about him? And also, what are we doing about the trust in an institution?" And we are, and so there's a sense in which where the issue that is pushed is not really about mistrust. It's about engineering to reach a result.
Yeah.
We who are the observers, we also buy into that story. We push it, and so we do not ensure that people have an objective faith in the system. So the media also has a lot of work to do, not necessarily to agree to the one party, but also to have, especially on a matter like this, to even invest in your own experts. You know what I mean? To be able to say, wait a minute, that story doesn't add up, and not just to call us pundits, because when you come pundits, sometimes you're also telling a story, but also to have your own independent perspective on these issues, because we need to ask the question, why is it the IEBC is so trusted? There were how many people there amongst the lawyers? There were at least 8 who had won seats. They were very happy to go and take an oath, and the election was perfect. They would be very surprised if the election was impeached, if someone filed a petition, because of course they won legitimately. But the same people will stand up and say this process is irredeemable. So there's a problem. There's a problem, and that problem is engineered to reach a political result. Yeah.
Let's take a break at 26 minutes to 8. We are talking about the petition, presidential petition. This is the 4th one since 2013. And what is the implication of the judgment of the 7 judges yesterday on future elections? Where are we heading? Like Abdikadir is saying, we have seen improvements by and by since 2008, since the National Peace and Reconciliation Accord and the Agenda 4 commissions and the IEBC into IEBC, and now going forward into the elections. What do you expect to see?
This is the Situation Room, the only way to start your day.
Kenya's biggest conversation, it continues. This is the Situation Room live on SpiceFM. Eric Latif, Ndu Oko, CT Muga. Our guests this morning, Senior Counsel Abdikadir Mohammed and Advocate KAMOTHO WAIGANJO. We are talking about what we are seeing coming out of the Supreme Court and the reforms that we have heard so far in our electoral process and what we expect to see going forward. Gentlemen, allow me to read part of what the Chief Justice read yesterday in the summarized judgment. And this was with regards to the alleged behavior of all the commissioners, right, at Bomas. We note that apart from their 11th hour denunciation of the verification and tallying process and their averments regarding the conduct of the chairperson, the 4 commissioners have not placed before this court any information or document showing that the elections were either compromised or that the result would have substantially differed from that declared by the chairperson of IEBC. Critically, they have not explained why they participated in a verification process when they knew that it was opaque up until the last minute. Indeed, the Serena Hotel press briefing, the 4 commissioners acknowledged that this far, the entire election had been managed efficiently and credibly. The chairperson on his part did not make matters any better by maintaining a stoic silence, even as things appeared to be falling apart. All this, in our view, points to a serious malaise in the governance of an institution entrusted with one of the monumental tasks of midwifing our democracy. An institution that obviously needs far-reaching reforms, of which we shall say more in our detailed reasons. So basically, the Supreme Court is saying, you know what, there's a lot of hanky-panky going on in this commission. There's a lot of trust that has been placed on this institution. It needs reforms. We are going to tell you where we think reforms need to come. Do you agree that we need more reforms in this institution, in our electoral process, Abdikadir?
Thank you. I think the Supreme Court was noting the fact that there was a breakdown as far as the governance of the commission was concerned. And that was obvious for everybody to see. The question that was critical for that particular court and that particular case was whether that had such an impact on the election management that it impacted materially on the results. And as far as that second bit was concerned, no, it didn't. The elections had already been done by the time these good people were addressing the press conference at Serena. And it had also been, the results had already been verified and tallied to a very large extent by the time they were. Remember, the last meeting at Bomas, where they have these final results, the 27 constituencies to be announced. When that meeting finalized and a group of the commissioners walked to go to the podium to announce, is when these four
also
packed up and went to Serena to address the press conference. So from where the court was sitting, by the time that was happening, the breakup did not have an impact material enough to impact on the results of the election. Having said that, they also note that there is a commission that has a major issue. And if, as I had said, if this was a corporate governance case, that would be the key subject. But the key subject now was something else. The key subject was, were the elections held? Were they credible? It was an election petition case. My own hypothesis is that that was part of and I'm theorizing here, that was part of the script that, look, in the event that, remember, the commissioners swore affidavits to say, we had visitors. People came to tell us, look, moderate the results. We need to go at the minimum for a rerun. And assuming that is the case, again, I'm hypothesizing, I think this was part 2 of that act, that if that didn't go through, then break up the commission and send this so that you then use that breakup as the reason for the court not to take, or for Kenyans not to take the elections as credible. I am hypothesizing, and that's my theory. But I think that was the case. So in as far as the case, the court then is saying we need to look at the commission and the way they run. I think that's evidently there for everybody to see, and something that's got to be done in terms of our election process requiring more reforms. I honestly don't think so. I think we are done with. Look.
So you don't think, like the judges are saying, this is an institution that needs far-reaching reforms?
I don't think so.
You don't think it needs far-reaching reforms?
As I said, look, you will not go to a position where you say nothing can go wrong with the IEBC or any other institution for that matter. In many places, elections are held by mid-level civil servants, and there's some box somewhere in some room, and you're told, please drop your ballots there. Nobody is worried about how many watermarks and security features that ballot paper has. Nobody is worried about whether the box is transparent or not. There are no armed security guards watching.
But if I may interject, is there not a reason why that has happened? To get these democracies to the place whereby it doesn't matter that you can send your vote by mail and go, about your business and wait for the results at the end of the day.
Or drop a pebble.
Exactly. There's been a progression.
Absolutely.
There's been a progression until then. And so are we not saying essentially that in order for that progression to take place, then there are certain reforms that need to happen? Like what you're saying, KAMOTHO, there is, in my opinion, there is no reason why we should have 1,000 agents all over the place in a polling station. There's no reason why one governor-elect telling us how he spent 15 million shillings to pay agents around the country. Why should we be doing that? But for me, the progression to get to that place with this example that you're giving means that something has got to give. Something has got to happen.
Not with
the transparency index.
Not with the election management process.
So where does this, and that's my question.
Our politics.
Where does this need to happen?
I absolutely agree with you that something's got to give, but not with the IEBC, not with our election institutions, not with our courts. It's to do with our politics, and it's to do with our culture in terms of our political hygiene, not where, because if I think we have gone to the limit as far as, I mean, our elections are the most expensive per
counsel,
capita in the world.
Senior counsel.
Yes, sir.
If we look at the focus that we have
Yes.
on what Brother WAIGANJO here put very, very well,
Yes.
the presidential election.
Yes.
You know, if we keep talking about our elections,
Yes.
we'll confuse
Okay.
issues.
Good point. Good point. Our presidential election.
That's where the problem is. It's not. It's
not all the
no, those are
1,889.
they are never ever
No
an issue.
And by the way, can I tell you something? You know, we complicate our we present our elections as if they are very complicated.
Right.
It's, you know, our election is actually very basic. It's very, very basic. And by the way, the most credible election in terms of at the polling station is the presidential one. You know why? Because it is the one that is counted first. So by the time it is counted between 6 and 10 o'clock,
Everybody's fresh.
everyone is fresh, everyone is awake, and everyone is present. And don't forget, our polling stations have only 700 marks. Usually they're about 400. So to count those votes is easy. They are shown to everybody. I've been in those rooms. And because you don't know how your candidate is performing, every agent signs the form. You know, so actually, there's no complication. The issue is not the election. The problem with the commissioners, and I think where the court is coming from, is recognizing that the elections are both a legal process, an administrative process, but it's also a political process. The commissioner speaking at one voice gives political legitimacy to the result. It doesn't mean the election is not valid, even when they walked out. But what they did was puncture the legitimacy of the result. And I think part of the reason why the court had to come very strong is to restore that legitimacy, to say, wait a minute, that puncturing of the legitimacy was not based on valid grounds. And I think that's important for us to keep recognizing that the commissioners are not about the election. It is not about the technical part of the election. The technical part of the election is actually very well done. This year's innovation in ensuring that everyone has access
To a portal.
and let me tell you, and you see that it's sad that in this country we're very good at poking holes and showing where things went wrong. But have you imagined that in a third world, and I use that word in
Banana
relation to
Republic.
how we are
CT
seeing.
will allow you even go further.
Oh, excellent. You know, is that in a country like this, that we actually had a system where everyone all over the world was trying to access, and I'm sure many were trying to, and it did not collapse. You know, that doesn't happen. In many places in the world, somebody would have been able to go through and do something funny, or the thing would have collapsed by day 2. So in a sense, in terms of the credibility, the technical credibility of our election, we have gone very far. The problem is the political legitimacy question.
So what kind of reform do you think the judges are talking about?
From where I sit, it's more a leadership training thing. I don't think it has anything to do with changing the law. You know, there's nothing, you know.
Is there nothing like, you know, holding all of them collectively accountable?
But they are accountable even now. You know, they are accountable as a commission, but you're also accountable as an individual. But you see, and also, let's also not forget, it is possible for there to be genuine complaints. You see, let us also not say that the commissioners must always speak together. There can be genuine reasons. But I think what this decision has said is, look, if you're going to do something like that, for God's sake, let it be because you have legitimate grounds. It cannot just be that you are doing this so that you can prejudice an election. That is actually the problem. And I think the court was very good, even in terms of its approach to the lawyers. By saying, look, if you're going to come to court, please come with credible grounds. Do not tell a story that is not credible. Because if you do that, what we do is puncture the legitimacy of an institution which hasn't done anything wrong. So fix our politics, where I keep saying that the law has taken us as far as the law can do. Beyond here, it's a human factor. Someone asked what are the reforms we need in 2032. There are very many things that were obvious from these proceedings that could have gone humanly wrong. It is a marvel that the 290 returning officers ended up at Bomas. It is a marvel. It's, you know, because it is possible to compromise that process. You know, because there's a human being who needs to bring a physical form, and that form can determine whether or not the result will be announced.
Yeah.
You know, I think I mentioned another time that there's a time in a county I was in The elections for governors are announced in the respective constituencies.
Yeah.
In the 4 constituencies, the results were announced. Then one of the returning officers disappeared or was disappeared for about 24 hours, for 2 days. So the result cannot be announced, even though the result is known.
He could not go to the county.
He did not take the result. And without that result being taken, even though the result has been announced, without that physical delivery of that form, the result cannot be announced. You see, those sorts of things, the law makes very many assumptions that things will go right. And those are the things we want to look at. Because if people want to compromise an election, those are now the areas you'll find in 2032. And we need to keep asking the question, what is a result? A result is a very simple thing. It is there in 46,000 stations. How do we ensure that that result is the one that is reflected in the announcement? Is our investment in technology overstated? Have we overstated the place of technology and in fact used it to question the credibility of elections because it's an opaque area, to use that word. It's an opaque area. Anybody can say anything. I can code server and entry and hacking. And most Kenyans don't know, but Kenyans understand a physical form. Where is that form? That form has a picture. That form, people have copies. What do we do to ensure that we do not introducing reforms, we actually don't prejudice the credibility of the election more by creating more and more steps which people can now impeach? So the problem is not technical.
So
the
what would we
problems are
do?
Politics.
So if we are to say, let's reduce the transportation of 290 officials to one national tallying center, then what do we do?
That's a conversation, and I think
if we post it online, then you are increasing the chances of someone.
I used to ask, all these elections are announced publicly. They are announced publicly.
Yes.
Yeah. What is difficult about actually relaying the physical because they are announced? There's in the 290 constituencies, the elections are physically announced. In fact, in the 46,000 stations, the election is announced publicly.
And the counting is public.
And the counting is
one
public.
Piece by one piece.
So what is so difficult about transmitting? Because clearly it appears we don't trust even our original forms that are signed by hand. In fact, the difficulty for the petitioners was to the Smoking Wajala question of, was it possible? Was that one hacked also? But it appears that it is possible then to hack that form because now we have realized how important it is. So we need to ask the question, how do we deal with the human factor in the next election? Because our problem is no longer now in the law.
Learned friends, I have to ask a question. Please, I come from the premise where when learned friends like you speak, my confusion doesn't reduce, it actually increases.
We must live here with less confusion.
Yes, because you see, I'm listening to all this, and the question that's in my head is: so, when one goes to court, is one seeking to find the truth in a situation, or is one looking for a legal solution? Because in my mind, the two are not the same thing.
Okay, so it depends on which system you are looking at.
We look at the electoral situation.
I hear you. It depends on which legal system you are looking at. The common law British system, which we inherited, works on something called an adversarial system. It is you being the judge in the middle, KAMOTHO and myself on two sides. We both argue our cases. We go 100%, and based on the law and the evidence we have brought, you as a judge, what do you believe? That's one system. The French system, and to some extent countries that follow Islamic law, the arbiter is also an active participant in the case, where they are saying, it's not just what the two of you are saying, but I am also seeking the truth. So I will actively participate and jump in and pull things so that I can search for the truth. So when somebody is adjudged not guilty in a criminal offense, it doesn't mean they didn't do it. It means that in the adversarial setup, the police or the prosecutor could not prove their case beyond reasonable doubt. So in an adversarial Anglo-English setup, or those that have borrowed from that setup,
The Commonwealth system.
yes. You are not necessarily looking for the truth or justice. Broadly, that is the basis, broadly. But the way you win that is you have two people who oppose each other based on the law and evidence and precedent, and a judge who is an inactive participant in this, who hears both sides and decides based on.
What system did our esteemed judges of our apex court use?
So ours is based on the adversary. Ours is common, British and former British colonies. That is the basis. What you want is, I know the law as a judge. I know the procedures. You have a lawyer. The IEBC had 20 or so law firms. The Azimio team had 50 or so lawyers. The Ruto team had. Present your case in open court. Let us hear your case and prove your case. The Azimio team failed to prove their case.
But time for the news, CT.
Time for the news.
Yes.
So part B of my question.
Part B of your question comes after the news.